Okay, well, we spent three weeks on chapter 4, and now we're into chapter 5 here. Boundaries in general. So we're going to look at some definitions, the rules of construction, monuments as boundaries, descriptive courses, and then quantity as boundary, maps and plats as boundaries, and then particular calls. So we'll see how far we get into this. I'm expecting this probably to be another 2-weeker, just as we get discussion going. I've really enjoyed the discussion we've had in this. So we'll just jump right into it here. Definitions. So the second paragraph, he states, a boundary in its stricter sense is a visible mark indicating a dividing line between two things, or it is that line itself. It marks off a given thing from other things, like in kind, as one field or country from another. A bound, on the other hand, is the limit or furthest point of extension of one given thing, that which limits it not being specifically considered. And he's quoting Burrell there. So I was going to throw out the question here is, how do you guys define a boundary when you're talking to a client or trying to decide, give them an idea of what it is you're locating? What definition do you put to boundary?
Hey, Trent, your screen that you're projecting there is all black. At least it appears that way on mine. Does everybody else see?
Same with me. Yeah, it's all black.
Okay,
Ditto.
try this one more time here. Is that better?
Nope. Now, there we go.
There we go. Yeah.
Thank you.
When I talk to students about what a boundary constitutes, this thing about where he says where there's a physical line or a visible line, that type, but it's not always a visible line. I tend to define it in terms of a legal definitions. It's where rights change. When you cross that line, something about the ownership rights or the rights associated with that property change, who has control of those things. So even like an easement, when you've got an easement on a property, when you cross the boundary onto an easement, you've got a restriction on the rights of the underlying fee owner based on what that easement's given up as far as rights go. So I have a tendency to do it in terms of a legal definition.
Okay, I like that. I agree with that. Challenge you a little bit, Jerry, here, because you're talking about rights, and surveyors, we don't deal anything with rights. We just talk about location. And kind of go back to my original question, we talk with clients about a boundary, right? We tend to generally be careful about talking about rights, but this is putting the deed on the ground.
Yeah. When you get into things like adverse possession and things like that, then you're crossing over into the legal side of things, and that's a court interpretation as opposed to a surveyor's interpretation. But when you think about it in terms of the written document, that's what the written document does. It explains where the extent of the rights are that are being conveyed from one party to another, whether they're in fee simple or in restricted and that type of thing. So I kind of tie it back to the document itself in that context of legal definition.
Yep.
Well, the location of those rights is certainly a surveyor's question. So if someone tells you to find the location of a sewer easement, for example,
Right.
The evidence is going to matter, but where the edge of that easement is, where the line for that easement is, matters as well. So yeah, what those rights mean may not be a surveyor's question, but certainly the location of them are.
Yeah. Absolutely. No, I want to challenge. I appreciate that Jeremiah and Jerry.
I explained to my clients that all I had to offer them was an opinion, which that I have no control as a surveyor over boundary lines whatsoever. I do have an opinion. And what I tried to tell my clients was that my opinion will be based on the geographical limit of their rights as an owner. and I didn't make any particular backup from whether that was due to adverse possession or color of title or where it was at. My opinion was going to be overarching over all things. I might be wrong, I might be right, but that would be my decision as the opinion. And that's what I had to offer. That's what I sold.
And I explain it in very much the same way, and I always make a joke of it. I like making jokes of myself. It's easy to do, but when I explain it, particularly in Utah, where our surveys are filed at the county surveyor's office, we've talked about many times here, it truly is the surveyor's opinion of where those boundaries lie on the ground. And sometimes I get some pushback, well, if it's just your opinion, why am I hiring you? And we talk about the expertise and the training and everything that goes behind that, and then we can talk about, there are legal aspects that I understand, but I'm not an expert in, I'm not a lawyer, but we can point you in the right direction. If there are ambiguities or discrepancies between occupation or the deed or deeds themselves, whatever they may be, we can point you in the right direction of some resolutions or some resources to resolve it, be that, some sort of arbitration or a lawyer or, working with a neighbor to resolve that, and then we can provide the maps to then back that up. But I always find it a little interesting to say that, well, this is just my opinion at the end of the day, on a base of a survey, and they're kind of thrown back. Well, why do I need you then? And explaining to that is a great opportunity for education. So he finishes off here the last two paragraphs. In summation, a boundary line is a line or marking, legal, natural, or artificial, between enclosures. If possession is without title, such as a fenced area not in conformity with lines of title, or between ownerships, if title is recited in a document, the describing of the boundary in words which delineate, quantify, and qualify the conditions by which the limits are to be established and held, it is known as a land description. When words or the lack of them or the arrangement of them used in descriptions result in ambiguity, both the interpretation of them and the physical location of the boundary lines from them become questionable. So the other the thing that popped out to me here, is he calls this, they're known as a land description. And I know we talked a few weeks ago, a few sessions ago, the difference between, well, what is a legal description, right? And isn't everything we do in essence a legal description? But he does use land description here. Did anyone else notice that?
Yeah, I chuckled when I saw it because I like using land or land boundary description instead of legal description. I mean, anyone can write a description, so what makes my description more legal than someone else's? That's my way of looking at it. But land boundary, I can say that with a little bit more authority.
Absolutely, but even any description that's written is going to be legal because it's written for the purpose of some sort of document recording or something to to be used, right? We don't just write descriptions to write descriptions, and so that's an interesting thing there. I suppose maybe we're talking about land descriptions because we're talking perhaps more about the actual bounds of a piece of property that someone would buy, and not the bounds of like an easement or something like that, though the same principles do apply in writing it. Maybe he's looking more at a true land boundary, a parcel boundary or something like that. Okay, jumping over to rule. Oh, go ahead, Jeremiah.
I just want to mention one thing that I just noticed, and we'll see this more when we look at the rules of construction, but that first statement that the words delineate, quantify, and qualify the conditions by which the limits are to be established and held. I mean, the intent is very important. The intent is the most important thing of a transfer of title, and so that quantify and qualify. I mean, qualify in particular, I forgot that word was in there. And often when we're looking at a deed, there are words, there are ties, there are calls to things that that are easy to overlook, like a plat or a map or a survey or another deed. And if you don't pull that document or you don't look at that qualifier, then you can entirely miss the intent of the conveyor or of the original parties to that document. But that word qualify, it just seems very impressive as I'm looking at it again today.
I like that, because that's gonna be really critical, like you said, in the rules of construction, but how we write it, not just in a meets and bounds sense, but then qualifying those meets and bounds to something, to a natural monument, to an artificial monument. I have a guy that recently started with me. Actually, he just had his 3-month review today. And he came from Texas, surveyed there for about 10 years after getting out of the Army, in a geographic or geomatic type role at the Army. Excuse me. And it's been really interesting as we talk back and forth, because Texas is a very different area to survey and then what we have been talking about. I mean, we're talking mostly Western states here in our participants. We do get a few Eastern states, and we've had some great discussions about the difference of those, but we haven't got much into the differences in how Texas and the history of surveying there. And, that's a lot more of a bounds state. We're making calls to things, and he's had a really hard time kind of adjusting to, some of the more simple descriptions that you see in Utah, a mathematical type description. And it's been interesting to me as we're reading and studying this, and then talking with him of how do we quantify and qualify those calls we make in a description so that they last, and are clear to everybody. So with that, let's jump into the rules of construction. Let's see here. Make sure I got this right. So anyone want to kind of go through how you understand the rules of construction and orient yourself to that when you're writing descriptions?
Well, I'll jump in here just a minute and say that if you'll notice, Wattles on some of these pages here has some footnotes in it to some cases. And I looked up a few of those. Some of them aren't easily found on the internet, but some of them are. And they're very enlightening about what the court has to say about how you will interpret the rules of construction. And while we as surveyors concentrate on where they start in talking about monuments, natural monuments, and then on down. But when you look at the court decisions, it starts with intent. The intent is an overarching thing that will trump everything else in the deed. And I have some cases here that if I could read them and find them, I made some notes that to that effect. I don't know whether it'd be worthwhile to try to state them here, but I will point out that some of those footnotes in the cases that Wattles gives you has is to me an important decisions or information than what he has written. One of the footnotes that he gave was number 13, Bloom versus McGregor. And this happened to be one that had a number of of items that the court had to say, and most all of them will be applicable to us as surveyors. And one of them was number 4, and the court there said such interpretation must be given to a deed as to make it effective rather than to defeat it. So when we read one of these deeds, we have to back out and look at the whole deed and make an interpretation of it that will give the deed effect rather than find an error in there that will defeat it. And then number 5 is a deed indefinite in terms may be certain by the conduct of the parties acting under it. So even though there may be some ambiguity that you get in reading the deed, if you can go on the land and you can determine the conduct of the parties that was done after the deed and without controversy, that can help you explain what the deed had to say, its terms. Number 6, an omission or a part of the boundaries or cause is not fatal to the validity of a deed, where such boundaries or cause can be supplied or the description rendered certain. Now that's getting pretty deep in the law right there. But number 7, if the description is indefinite, as by the omission of a line, then a statement of the quantity may help to locate the boundaries. So you can have a completely missing line, and if supplying that, you match the acreage, the court may let you do that. Number 8, in order to determine what land was intended to be described in case of ambiguity, the description may be read by reversing the courses. Now that right there is really important to us surveyors. I mean, probably all of us have had a field crew come in with a traverse that had a major angle bust blunder to it, and we know that if we run the traverse one way and then reverse it and run it the other way, that point that wind up with the same general coordinates on it is where the angle bust probably occurred. And here the court has done essentially the same thing, that you can run forward or you can run reverse, if that helps you to understand the intent. And number 9, in general, if a competent surveyor can take the deed and locate the land on the ground from the description contained therein, with or without the aid of extrinsic evidence, the description will be held to be sufficient. Now, all of those things, or most of those things, are highly important to us as surveyors, that we understand what the court has to say about what we do. And that one particular case had several things that I thought was applicable. And I don't know whether anybody else looked up any of the other cases or not, but I'll refrain from going any further until we get a little bit further down the line with our study tonight.
Well, thanks, James. I appreciate that. That does give a lot of clarity to what he's trying to explain here. You know, to kind of reiterate what you said and what Wattles is saying. I highlighted a sentence here, but the first part of that paragraph says the intent of the parties is to document. If the intent can be gathered from the language used, it is a controlling factor, even over the usual guides. And then the last sentence there, a deed is to be treated in the same light as a contract, giving full import to the intent if it can be ascertained, right? We're supposed to put ourselves in their shoes and their time. A lot of what we read in evidence and procedures talked about that when we looked at history in words, history in actions, and some other chapters in there, right? We kept going back to what was common then, what was the acts then, what was the intent back then, and putting yourself in that, looking at the language and putting what would they have said there versus what we understand words to be today. So I like that. I appreciate it.
One of the things that I see in a lot of survey books is it admonishes us to follow in the footsteps of the original surveyor. Unfortunately, when I read court decisions, I don't see that language. What I do see is that if a deed requires us, if it refers to a survey or the monument set in a survey, then we have to follow that survey. But just because there's a survey, we have no reason to want to follow in the footsteps of a survey if there is not some connection there to the deed. Some of y'all may not agree with that, but that's my finding.
Okay. I'd say they go hand in hand for sure, right? The deed should be based off of some survey at some point, whether it be the original survey, right? The GLO survey, the actual deed itself could have been written by a non-surveyor, but it is based at some level off of a survey. So retracing that, you do need to go back. So I understand what you're saying there. The first is intent, and then if that intent is to reflect a survey, then you follow that survey.
The problem is when you have a deed that's slightly different from the survey that was done at the same time, and there's no mention of the survey or its monuments in the deed itself. Suppose you had a small tract of land in a corner of a 40-acre tract that a guy sold, and he defined it as the east 150 feet of the south 200 feet, located in the southeast corner of this 40 acres. That would be a sufficient description. But then suppose that a survey was hired and he monumented that at 150 feet by 200 feet. And then the deed comes out and it says, start at the southeast corner of this quarter section and run west 140 feet and then north 200 feet and east 140 feet. In other words, the deed says 140 feet, but the survey that was done at the same time says 150 feet. And you can go out there and you can find the monuments to that survey at 150 feet. It's been recorded. Can you use it? Is it controlling, or is the deed at 140 foot controlling?
Well, it's the intent that matters, right?
Yes, but it is the intent that is expressed in the deed.
Well, and that's one thing to mention about the deeds. The deeds are like contracts. There's got to be a meeting of the minds. And so the two parties, the buyer and the seller, must have come to an agreement on where that parcel was. So was it the 140? Was it the 150? And those are questions that they will ask as part of this process to figure out what was the actual intent. Did they intend to sell the 150 foot parcel or the 140 foot parcel? And so even that might be a latent error in the deed, something that wasn't necessarily intended to be on the record, but it expresses there was an agreement, but it misrepresents what the agreement was. So,
And the flip side of that too is, was their intent to sell 140 feet, but was their understanding that the monument set was 140 feet, right? And so the intent may have been to hold to the monument, but their understanding was wrong. That's a hard thing about survey, right? There's a lot of what ifs that you can go back and forth on. They could have thought that those monuments were at 140 feet. That was the intent, to monument 140 feet, but it was monumented wrong. But ultimately, the intent was to go to the set monuments. That's a hard one to kind of put a finger on and to go back in time. It's the hardest thing about surveying.
It's not hard to me at all. If the survey is on record and it shows 150 feet, and that's where that surveyor set that monument, it doesn't matter to me. The deed says 140 feet, and there's no ambiguity in that deed. So it's 140 feet. Now, what those guys trying to read those grantors' mind about what he intended is a mistake that the court will not do if there's no ambiguity. It's going to be 140 feet. That's the way it is. At least in Arkansas, maybe not in your state, but that's the way it's going to be in Arkansas.
Well, occupation can certainly be evidence of intent, and that's one thing that is considered by the courts. What did they ultimately end up occupying and transferring, and that is something that needs to get taken into account, at least in my mind.
Well, the statute of frauds exists. I mean, contracts exist because of statute of frauds. And as Jeremiah said before, the deed is a contract. There's a contractual relationship between the grantor and the grantee. It meets all the requirements that a contract under the statute of frauds is supposed to meet. And if you look at any contract law decision made by the courts, and I pretty much guarantee this is pretty much universal everywhere, the courts are going to say, we're not going to read into the minds of what they intended. What they intended is what's in the contract. That's why the contract exists. Everything was supposed to boil down to the words, so that there's no question outside that later on. And that's supposed to hold true then for also a property description or for the deed for a property conveyance. So we got to be really, really careful and get away from this, because I've seen some people go, well, what they really meant was, no, what they meant was what's written in the description. And if there's a call for physical monumentation, and that monumentation conflicts with what's written as far as numbers are concerned in the description, that's where the rules of construction come into play, is what kind of weight do we assign to these different elements of evidence, and how do we reach decisions based on what is our best opinion of where the corner of the boundary is.
and let me clarify, I agree with you, Jim, about what you're saying. Because most of the time we're doing boundary retracements, we don't have the opportunity to go back and talk to the original conveyor. We can't go back and say, well, did you mean the survey? What did you both actually mean to do? And if there were some way we could do that, then they would also be able to file or record a corrective deed to make sure their intent was clear. But that's not usually the case. And if we're coming at this, 20, 50, 80 years down the road, and there's no way to tell what that intent is, you do have to go off of what's clearly in the document. And then you do have the rules of construction and other evidence like occupation, like fence lines, like the surveyed line that might clarify things. But let's also, just remember, at least here in Utah, a survey is not a document that conveys title. I don't think that's anywhere in the United States necessarily. It's an opinion from a professional, like we were talking about before. So as such, it could have been, very likely could have been, the survey was done at the same time as the deed that was recorded, but they saw where the surveyor put his marks and said, heck, we don't like this. Let's do something different. And so they did change the information. It gets back to the same thing that we were just discussing. We can't go into the minds of the original conveyors, especially if they're not available. And so we have to take it at face value. What does it actually say? And what does it actually express?
Exactly.
Yep. No, and I agree with what you guys are saying. My point was, to walk that ambiguity, what, joining owners and other evidence is in there. Correct. The deed is what the deed is, the contract, and that's what we show on our survey. But there might be other factors that need to be shown, discussed, or disclosed on the face of the survey. Perhaps, an adjoining owner that then did wrap around that 10-foot ambiguity, if you will. And so there are other factors that need to be shown and considered when we retrace it. You can't just go on the deed is it, and put it on the ground despite everything else. You take that and the adjoiners and the field evidence and everything else that's there and put it to gather as much evidence as you can. Too often I've seen surveyors that just, it's the deed and that's it. I don't look at anything else. And in doing just that, they can create problems where there is ambiguity that they're not finding. Great discussion.
I guess one of the things we need to recognize right here is what is a part of the deed and what is not a part of the deed. Anything that's mentioned in the deed, such as a record, becomes incorporated within the deed. It is to be read as if it was in the deed.
Correct.
If it is not referred to in the deed, then it's extrinsic evidence that might be used to explain the terms that are in the deed, but it can't put something new in the deed. That's the way I understand it.
No, and I agree with that. And that, yeah, I don't mean to say that you would be adding stuff in, but it's, there is adjoining rights, adjoining owners, junior, senior rights. There's a lot more than just, again, I've seen surveyors or surveys that they just take the one document, put it on the ground and walk away. And there's so much more to gather and look at than just the one document. But you guys, I agree with what's been said, that is what we are putting on the ground, but we have so much more of an ethical obligation to look outside and around and gather all evidence to defend that. So monuments as boundaries. So he talks about artificial monuments, natural monuments. And he even puts a little caveat in here. Sometimes the artificial monument can be referred to as an incorrect or not true representation of a corner. I don't know that I've ever seen that term specifically used in that sense. More often it's some sort of man-made monument, a barn cap, a brass cap, a section corner, a property corner that's been put in, a party wall, as he puts it in here, and some other type of, man-made feature. I think in the West, this is what I'm, when I worked in Ohio and West Virginia and some of those meets and bounds states, you see a lot more calls to everything. Everything's called, calls to Grandma Annie's, property that she owned in 1890, and it's, really, really old calls you'd have to trace back to forever. The guy that works for me now from Texas, everything was called to something. He's a lot more used to seeing it, and then he's kind of blown away by our Utah PLSS deeds. I know California's got the same one. We drop a lot of calls in our deeds, and we can do a lot better at putting more calls in there. Calls to a found property corner, calls to natural and artificial monuments. I'm thinking most everyone here is kind of in those states we're talking about. Teresa, you're in California now, right? But you did some stuff in Minnesota, if I remember correctly.
Yes.
Yeah.
And so the longs and twos more that I've learned more being out here in California than in the PLS state, because we always started and came from section corner information. So that it was always monumented to and from the section if we were doing plats or legals.
Anyone else had any interesting experiences with calls to natural artificial monuments? Any unique situations there? Kyle, where are you from? Where are you surveying? You another California guy?
Yeah, I'm in California, Northern California, so a little bit different than the Southerners, but pretty much the same rules that apply. That's where my question is purely for Californians, because we make a lot of houses and fences into monuments when we show them on records of survey. And I'm convinced that when you do that, you're making the poor people who live there commit misdemeanors without realizing it. Not that anyone's gonna get charged, but you know, you should if a house is a monument, shouldn't you then be doing a corner record to do monument preservation if you're going to do an addition to that house or something?
Give it a shot of fluorescent paint as you go by.
I never thought of that, but that's a fair point. So I mean, the one takeaway I have from here, and the one lesson that I'm trying to do better at is bring more calls to something. I happen to read a deed today that says beginning at a point at a found rebar and cap. They called out the company that was on the cap, and then running, then tied that point to a section corner, as you would, and then they ran around the deed. And I happen to have that barn cap in my survey, and so it was really easy to fit things in there that didn't fit very well before that. So it clarified quite a bit there for me. So just kind of that lesson learned to always do a little bit better for me. The next section here is agreement or acquiescence. And this kind of gets to some of what I was hinting at before. And again, this gets in that gray area for surveyors. We understand it, we deal with it. In Utah, we've got very specific laws on how we document it, whether it's to a boundary adjustment or a boundary line agreement, because of some sort of acquiescence or agreement there. And so we get tied into that quite a bit, but ultimately it's not ours to make that call that this rule applies at this point. But he does say, in looking at fence lines, disputed boundaries, etc., one must remember that there is a difference between agreed boundaries and boundaries by acquiescence. An agreed boundary could be synonymized by classifying it as a compromise boundary. In other words, any dispute or doubt over the locational line was settled by a compromise of the claims or positions of the concerned parties. On the other hand, acquiescence in and to a line is not based upon a dispute or disagreement as to the line's location. In the case of Kierkegaard versus McLean, an arbitrary line on what both parties believed was the true line was agreed to for the purpose of building a fence, and without recourse to survey to determine the true line, this might have constituted acquiescence if both parties were mistaken, but acceptance of a line not known was enough to support the trial court's conclusion that there had been an agreement to locate a doubtful boundary. How much do you guys deal with boundary line agreements, boundary by acquiescence, boundary line adjustments in this case, and how do your states handle it?
It's a mess in Arkansas, I can tell you. And almost every litigation that you get into is going to have one or both parties that are going to be arguing either adverse position, boundary by agreement, or acquiescence. It's there in almost every place. And unfortunately, some of our surveyors haven't given the court what they really need to make an intelligent decision. And the court must make a decision. They have to resolve the controversy. And so those decisions, especially at the trial level, they can be off the wall. At the appellate level, things get a little bit better, but not a whole lot. The one problem that I have in Arkansas is with adverse possession, and unfortunately, when you read the law, it seems real simple, but when you get into the actual application of it, it's a little more difficult because adverse possession is not usually based on one act that a landowner committed. You can compare one act with all of the requirements for adverse possession or acquisition or even agreement and make an intelligent decision. But that's not the way the court works with it. Every act that the owners took is taking into as an aggregate. And so with adverse possession, you might have one item that was there for the entire 7 years. We have a short period, and that's unfortunate too. For 7 years, that was open and notorious, and it was just a foot or two across the line. But then another act that encroaching owner did was to pile leaves or lumber or firewood or whatever across the line. And then, but that wasn't continuous. It was there, but it wasn't continuous. Then you have the guy that mows part of the adjoining land, or goes over there and cuts some trees and then gets back on his side of the line. And all of that is taken as an aggregate. And so one act may solve some of the problems with or some of the statute that's recalled for with adverse possession, while another act may cover some of the other items. And the court will take that into aggregate and say it was adverse possession because when you take all of the acts together, it's adverse possession. And that just I've done hundreds of almost rural lot surveys, and if you take an 80-foot lot and put a 70-foot house on it or a 60-foot house, it's going to get close to the boundary of the adjoining lot. And if the adjoining lot is not built on for years, it grows up, and the owners is going to cross that line, and they are going to encroach on the adjoining property. And if there is just one tiny little thing that satisfies the 7-year statute and is open and notorious, then the court may award that adverse possession for a major part. All of it that has been used to the adjoining property. And like I say, it's a mess. I don't really want to, I would hate to have to survey in today's environment in Arkansas. I hope things are better in your state. And one of the reasons I'm here is if you don't realize that these things happen and you don't stay on top of your profession, you will be in the same boat as Arkansas surveyors are in. It's important that you pay attention to these litigation that are going on and that you don't hide it from other surveyors. If you're in litigation, all surveyors have an interest in how that's decided, especially if it's appealed, because if it's appealed, it becomes law. I'll get off my soapbox.
You're good, James. Thanks. Sounds like your adverse possessions are fairly similar to Utah's. We've got an openness torius, a 7-year period, and we've got this list of requirements that you have to meet. Generally I try and, do some sort of mediation before it gets there. And if we can work something out and get to some sort of boundary line agreement or boundary adjustment, if needs be. Luckily, I've never had one that's actually gone to some sort of adverse possession case. We've been able to work it out, at the lower level there. Anyone from the other states? Jeremiah, certainly speak up more on Utah and your experiences, but our other state experiences here,
Well, I can say about Utah, the one thing that usually kills adverse possession is that, well, first of all, it's really only the only land boundary case law principle, I guess you could say, that is statutory. There is law on state code, in state code, that specifically talks about it. And the thing that kills it is taxes. You've got to pay taxes while you're openly and notoriously using someone else's property. So how do you do that if you don't have a deed on the tax ledger? And a lot of the counties will not record a deed if you're not the owner of record. So it's very difficult in Utah because just the way the things are working. I have seen it, and usually where it comes up is because there is an overlap between the deeds. And so both of them are technically paying taxes. And so the kicker there is, where's the line of occupation? And so it ends up being a question of who's using it at that point. We had a case recently in the last, 2020, where over the period of about 40 years, there was both acquiescence and adverse possession, and then acquiescence again. And it switched between the two landowners at least twice because they had met the statutory requirements for both at one point in time, acquiescence, and then adverse possession, and then acquiescence again. It was really wild, but it worked out. I think, at least the courts thinks it does, and I'll agree with them.
How does it happen in California, guys?
We have lot line adjustments, which are, boundary line adjustments. It's the same thing. Typically, it's 7 sentences of the Subdivision Map Act. So there's not a lot telling people how they have to get done, or, basically every city and county, they put their own different types of requirements on it, but it's kind of an interesting thing because you could solve a lot of people's problems by just doing a lot line adjustment right off the bat instead of having them talk to attorneys and spend, hundreds of thousands of dollars fighting things out in court. It's just, you guys can resolve this problem and spend 10 grand doing a lot line adjustment or something like that. And, everybody takes up a chunk of that money, but it's probably cheaper than going to court most of the time.
Absolutely, it is, and that's why I said I try and get it to some sort of mediation. Part of our ethical obligation is to talk to landowners, right, and talk to the adjacents if there is some, and try and get the full picture. And too often we don't do that. But by building those relationships, talking with them, usually you become a trusted person. I always explain that a surveyor, while hired by a landowner, is an independent viewer of everything. And my purpose in being there is to understand how everything falls, and if there is a problem, then let's work it out and see if we can't not get it to go to some sort of arbitration and spend that money for lawyers and everything. And often that in that case it's usually who has the most money wins, who's to fight it longer, unfortunately.
There was a surveyor on Mentoring Mondays maybe like a year, maybe 2 years ago, that was talking about just that. He became a professional mediator as well. I don't remember who it is off the top of my head, but it was a really interesting talk, just because it's like, look, you can save people a ton of money, they'll be happy, and you'll get to resolve these issues instead of sending it to two attorneys who might not know the ins and out of the case.
Yeah.
Pretty interesting.
Yeah.
I could also look that one up. I know John Stahl speaks on Mentoring Mondays quite a bit. He's out of Utah. He does a lot of that type of stuff. He does a lot of those higher profile ones here in Utah, and always has some cool stories there. I try and stay out of that limelight where I can.
I want to say it was farther east than further east than that. It might have been Wisconsin or it was somebody back east, or more east than California, at least.
Okay. Everything's more east than California, Kyle. That really
can I-
is down there.
Can I ask a quick question?
Absolutely.
Regarding this adverse possession, paying taxes on it, because California, as far as I understand it, seems to be much the same way, where you have to pay taxes on the land to have an adverse possession case. And while that doesn't seem possible to do in most cases, my county, the county assessor tax page, anyone could go and pay my taxes. Nobody has yet, but anybody could go on there, and as long as you put a credit card in, you can pay taxes by assessor parcel number.
By the way, that's an invitation for all of us.
If you want, you guys, you can even have, come take a corner of the land. It's, we got space, but it's just kind of interesting that there's that option where really, if I was occupying, I probably could start an adverse possession case. It'd be a long time to ripen those rights, but
And I think every state's going to have its own requirements. In Wisconsin, we have 3 time periods. We have 20 years, which is just straight out adverse possession, no payment of taxes or anything. It has to be open, notorious, and so on and so forth. This 10-year period does require payment of taxes, but it also requires that the deed be recorded and that entry upon the land to be within 30 days of deed recordation. Then there's also 7 years, which is the same as the 10-year one, except there's one additional thing I can't think of off the top of my head. But each one's got a little bit of a stricter requirement. Normally, when you run into the payment of taxes as a legitimate claim, Jeremiah was getting at this, is when you've got an overlap. And a real common case of that situation is going to be with the meets and bounds description. You got junior and senior owners next to each other, and the junior owner overlaps onto the senior owner. Until a lot of the GIS systems came in and started identifying that we got some issues with respect to some boundaries in some places, that wasn't an issue. I mean, people just wanted to pay taxes on overlap properties all the time, but that's a legitimate basis for a claim. Usually you don't have that happen in a simultaneously created situation like a subdivision plat.
Well,
And I wanted to speak one more time about the lot line adjustments. Like in Minnesota, we do the lot line adjustments, but you can't create, just like in California, you can't create more lots than you already have. So it's they have to transfer it, and by filing a deed, I mean, there's some simple processes, but some of our codes out here in California are sincerely lacking on the perfecting part of the deed transfer. They think, oh, I just have to file that proposed whatever with the city, and nobody goes and transfers it through their perfecting deeds. And it's one of those things that you have to be very wary of, because some of these cities within their municipal code don't give you a clear direction. So I feel like I'm always explaining that process out here in California more so than I do in Minnesota, because they don't just transfer through a plat, you transfer it through your perfecting deed.
The plat's only for the surveyor's office and for
Correct.
the assessor to see.
Correct.
And otherwise, it's all by deed. And at the County of Orange, that's our surveyor that handles the lot line adjustments there. That's probably his number one thing to battle with people on.
Yes.
I've been burned on that in prior practice where the deeds were not perfected. And now I see it on a weekly, if not more often, basis with the County of Orange. And that's just not something, it's not something that the tile companies really look at. They know about it, and they know you should be doing it, but they don't tell the property owners that that's what they need to do. And the county of Orange, I guess, doesn't do a great job of it either. Once the lot line adjustment is done and recorded, and people say that's it. And no, you got that other step to go through still, and many do not. Many.
Sorry, I lost the internet connection there for a second, so catching up to the conversation. And in Utah, the recorders function, and I'll really dumb it down here, is they're a human filing cabinet. Their job is to take a deed or a document and file it, record it, index it, if you will, so it can be found again. But over time, they've been doing a lot more gatekeeping, where they will file a document, but they won't do what they call indexing it, right? They won't transfer ownership or title of a portion of that. They'll flag it as insufficient. And, the problem is here, I think is what you're saying, David, is, in Utah, the cities are the land use authority. They're the ones that ultimately have the power to approve a subdivision. They're the ones that ultimately have the power to approve a lot line adjustment to make sure it still fits within zoning regulations and things like that. But often people will file their own deeds and go around the city. In fact, I've been dealing with a quasi subdivision in the western area of where I generally survey, where a developer went in and he got a surveyor to write him 4 lots and a connecting road with a cul-de-sac at the end, and he filed these lots as a subdivision at the county recorder's office. And because they were deeds, the county recorder took it, recorded it, filed it, created new parcels out of it, split it up. It wasn't flagged, and no one, the surveyor unfortunately didn't even tell him, hey, you need to go through the approval process to subdivide it. Where I come in is I have a commercial client that bought one of those lots intending to build, a new warehouse on there. And so he goes to start the discussion with the city prior to engaging me, and gets shut down. It's an illegal subdivision. Now you're going to have to go do your own subdivision. And it took 2 years, and he eventually gave up because he had to go rent out another space to move his building into. So now he's on a 5-year lease and can't do anything with the property that he bought, because he bought something thinking it was divided correctly. And again, the county just took those deeds and recorded them because that's their job, and surveyor didn't flag it. I don't know if there was a title company involved or not that didn't flag it and say, hey, you're going outside of established protocol, which is very clear in Utah, what that process should be.
Now, I'm going to kind of pop in, and this might not be a popular thing, but there's nothing that the land use authority can do that would obligate you or restrict you to transfer title or from transferring title. And if you want to sell a portion of your property to the neighbor and you want to do that subdivision illegally, you have every right to do it.
Correct.
But the city has no obligation, of course, to give you that permit. And I can see all the problems that can come from that because I deal with those. I'm sure we all deal with those all the time. But it is strange to me that there wouldn't have at least been some counsel from the professional, right, who in their ethical exercise of licensed authority should have told them that the proper way was to go through the city. That's what happens most often that I see is because I have a client who is literally just that way. I will tell him this needs to go through the city. He's like, I don't want to. Just write me the description. I'm saying, okay, I'm just letting you know. And I make a note of it and I move along. because he's been doing this now for 20 years. But the city has always come back and said, well, you need to do your subdivision anyway. So I end up doing it for him anyway. But it just ends up costing him more because he doesn't follow my advice, and that's not my fault. He hires me for the service, and I give him the service that he hires me for after having advised him.
Absolutely. I think that's a fair way of doing it, right? They have their land rights for sure. Any other questions or discussions on acquiescence, adverse progression? I don't think I had anything else in the book that I actually wanted to highlight. I think we've talked about a lot of the stuff here and even gone well above and beyond. Okay. Hearing nothing, we'll move on here. Descriptive courses. He starts out by saying flat calls are just a citation of a direction and distance with no qualification and no tie to anything at the end of the course. This is sometimes called a mathematical line because of the absence of physical attributes. Otherwise, calls include an assignment of a condition to either the direction or the distance or both, or to the terminus of the course. And he gives some examples there. So having reread this one, and it's been a long time since I had read Wattles, I want to call Utah a flat core state, not a PLSS state. That's going to be my movement in February in our upcoming professional conference. Is I want to get that vocabulary put in, because too often we're doing flat calls and everything, and I'm just as guilty as everyone else. So that's pointing to myself. So he gives some examples and says, in writing descriptions from the work of a surveyor, several questions must be considered. Are the surveyed lines free lines? That is, are they new creations in an open area, non-dependent upon boundary conditions, or do they follow in whole or part existing lines of record or ownership? And so I just was going to throw this out to you guys: is how do you guys try and be more descriptive, or how are you descriptive in your calls? What are some examples and some lessons learned there? Or David, what do you see that you really love saying, and what are the ones you like that just the language just doesn't make sense even?
Just to be as descriptive as possible is what I have learned. Use as many calls as you can when you should, but there were plenty of times when I was writing legal descriptions that we had flat lines. I had plenty of legal descriptions where I was just writing a flat line, okay, bearing and distance here or there, and that's where you went. But if there is a call, then you need to make sure you use it.
Agree. Anyone else have any thoughts or examples of stuff you've seen, liked or didn't like in a descriptive call? I'll give an example here in a second. No one else has one. I've talked a little bit about how a couple of years ago Utah passed this law about state plane coordinate systems, and surveying, any surveys need to be done in state plane. And in a couple of the counties, it really caused some confusion. One in particular that doesn't have a record state plane coordinate system. They've held this kind of bastardized 29 system and have held with it. And almost every deed in the county follows this rotation. And the county, in trying to follow this new state law, was requiring either some sort of rotation to every bearing, or some call of rotation at the end of a description, and in doing subdivision plots, there was some confusion. Okay, do we survey in this one or the other one? Do we respect it or not? And I was recently retracing a plat that was unique, because on the west end of the plat, it had a record boundary line agreement. It had some record calls. And then they created a new boundary along a road where they accepted out a portion of the overall original parcel. And it was really interesting in punching it that, they had both calls. They had their NAD 83 rotational call and then the county coordinate system call in parentheses with a record connotation to it. And so as I just started in just punching it blindly, and I noticed that right off the bat, knew the era that the plot came from. I just started rotating everything to this county coordinate system because that's what I was working in. And then all of a sudden I hit all these courses that were on a different rotation. I had to go back and kind of rotate all my lines back to the NAD 83 so I could close it out. But it was complicated, and because they had 2 calls for everything, and then all of a sudden they stopped doing record calls because they were creating new lines, so they didn't have any record on there, any record rotation. So in essence, they almost had 2 rotations in their plat there. It was a difficult one to kind of retrace and reread as you're sifting through all these calls. But the nice part is they did have all these descriptive courses, right? Where the record calls were, they called out, along a boundary line agreement, the following so many calls. And then we hit a subdivision, and along this subdivision, the next 5 calls. And so despite any rotational errors or confusion in the way it was written, it was really easy to retrace because the description of what they intended to follow was very concise. I knew I was following this boundary line agreement. I knew I was following the subdivision, and then we hit this, northern right-of-way of a road where they were accepting out the road out of the deed. And there was no rotation to that one, but I still knew what they were trying, the intent was there. It was simultaneously one of the most frustrating subdivisions I redrew, but also one of the best ones because everything was described. Every call had some description at the end of that, and it wasn't just record, it was record to something, which was really great. Here he says, let me find the highlighter. Let's see, I lost my, that wasn't what I was going to highlight there, but for safety and security in writing descriptions, boundaries of whatever sort, natural, artificial, or legal, abstract, or concrete, should be incorporated as much as possible as an integral part of each step around the perimeter of the subject area. Returning to lines again, if the identification of the line is only its direction and distance with no control attached along the way nor to the end of it, is called free line. Such lines may be created either by a surveyor in the field or a draftsman or scrivener in the office. Again, just kind of reiterate what we've been talking about is having these lines fixed, called to things. He says the identification of lines develops from characteristics that are either inherent or applied. In other words, if the boundary line follows a river, the inherent character of the qualifications assigned to a river applies to the interpretation of that boundary. If the qualification is assigned to the line that it be and that it follow the southeast side of Jones Building and the prolongation thereof, then that applied characteristic controls the line. And so as much as we can, calling out to monuments and controlling factors. Question, I think that's pretty cut and dry and simple. It's just something we can all do better at, I think. Again, pointing at myself. Okay, let's jump into.
I've got one other question about monuments.
Yeah,
that,
go ahead, James.
Some of y'all might enlighten me a little bit about your situation. And that is the monument that gets moved. And I find this to be more of a problem in subdivisions than I do in rural larger tracts. It was something that came to my mind for many years of surveying in the same area on subdivisions that were 5, 10, 30, 40, 80 years old. And it seems that monuments do get moved. I'm talking about monuments that may have a surveyor's cap on them or whatnot. How do I know that they've been moved? Because some of mine got moved. But generally, a lot of them get moved in a subdivision because of construction. In our area, it's very common for utility boxes to be set on the lot corners. And consequently, it's real easy for a backhoe operator installing these or replacing a water meter or whatever to accidentally dig up one of these fins. And these guys get absolutely chewed out if their company has to hire a surveyor to go back in and put that in there. So the individual backhoe operator out there, when nobody's looking and he digs one of those things up, he thinks, oh my God, and he jumps off and he grabs that bar up and he goes back out there and he says, it's got to have been come from right here. And he sets it back in place. And it's obviously not in the right place. And the other case is in construction. Sometimes you get a house builder that builds something and he's a little bit too close to one boundary. It doesn't match what the city requires for setback lines on the lot. And those guys will move those corners a foot or two if it solves a problem with them in the city over about them encroaching on a setback line. So, and you find this out when you go back in there and you do a survey over a significant part of the subdivision, you will find that it is slowly erodes. It's like you took a photograph and you run it through a copy machine. The first copy looks pretty good, but if you take that copy and run it back through and get another copy, it's degraded a little bit, and then another copy and another copy, and you get down to the point that you can hardly even recognize the original photograph. And that happens a lot out there in those subdivisions. Slowly, pins will become degraded slightly, and then the surveyor has to go back in there and look at what the original geometry was in the subdivision and find the pins that fit that geometry, because the ones that don't, they've probably been moved. We can say that, well, it was, only a foot off and was probably set a foot off. No, it probably wasn't. If there is a spot that you can identify, a location that would fit all of the criteria marked on the subdivision plat, that pin probably got moved. I don't know how y'all deal with this. I've heard a little bit about lot line adjustment or whatever, but how do y'all deal with this as a surveyor?
This is an interesting one that I struggle with ethically, because we have in our statute that we have a time frame to file a survey, set property corners after a plat's been filed. But we might file a plat, record a plat, and there's construction still going on, right? And so do we go out there and set all the property corners knowing that they're going to do grading and house building and all this other stuff and take out all those corners? Or some of my contractors and developers, I have a good enough relationship with them that they let me know when major grading work is being done, and then I go out and set that. And I mean, we probably ought to turn off the recording here. Am I in compliance with the letter of the law? Probably not, depending on some of the time frame on those. But ultimately, do all my corners get set when they're useful? Yes. Before a landowner then comes in to build a fence, before a developer maybe uses those property corners to build a home. But in that case, I'm not going out 3 or 4 times, sometimes to replace corners that get taken out by construction activities. But that's a challenging one. I don't know that I've had many times, or I can point to any time that I've found out that I've had a corner moved. Certainly, I've had a lot of corners ripped out, but rarely, I can't think of any instance where I've had a contractor go put a corner they ripped out. I guess it's a relationship thing that I get a call from those guys and say, hey, we just knocked a couple of these out. Can you come set them when you have availability? We're done working in the area. But that's a difficult one because once it's set, what is your obligation to track it and make sure it's there permanently and correct?
One of the things that we get into too is, let's face it, as good a job as we might want to do, there are some of those pins that we drive out there that are going to be an inch off. I don't care how good a surveyor you are. There is going to be some discrepancy between the ideal position that you have computed on your subdivision plat and the pin that you drive up out there. Well, then there's surveyors that follow you out there a few years from now, and one of the pins that's now missing, they set up on a couple of pins that look pretty close for distance, and they say, these are the best 2 pins I can find in the general area, and they start setting pins off of those 2. And it just so happens that those 2 weren't exact. So the monuments that they set may be more in error from a bad angle than the 2 that they started from. And this slow erosion takes place over 10, 20, 30 years. And it begins to become a problem for surveyors to actually go in there then and set something that's close to the original geometry, unless, there's sometimes that you've got fences or walls or whatever that indicate where the original pin actually was. Man, it's pretty easy to spot the pin that's been moved, but that's not always the case. And it comes to a judgment thing, and it's really the difference between being somebody who does technical work on the ground and somebody who does professional work, because you have to make those decisions about what your opinion will be on that matter.
I think that's
Well,
more of a procedural problem to me, if I hear you correctly. And if I'm going to go, if best evidence is a couple of property corners out there, I'm going to go try and hit other existing ones out there, even though I might be holding 2 closer to my survey area. Generally, if I can, my first setup is a centerline street monument. Hopefully those are set just a little tighter with a little bit more care, and then I check into property corners. If there are no centerline street monuments and I can find property corners, hopefully I'm finding other property corners. I'm thinking of an area that's kind of rural cabin area up in the mountains where there are no centerline monuments, but there are, over a 4-section area, a handful of original property corners. And you go out to the extremities, you actually start seeing some consistency there compared to maybe some of the newer ones, like you're saying. But I think, like you said, that's the difference between a technician and a professional on the ground, right? But that to me sounds more like a procedural error than anything. Anyone else have any thoughts or comments on that, on monuments and retracing them and setting them? And
Well, hopefully you're using more than just 2 monuments to set a whole bunch of other monuments out there. Hopefully you're using more evidence than just 2 monuments, and hopefully they're record monuments. Down here in Southern California, we also have a situation where we have a contractor working for a city, as far as we've been able to figure it out. We have a lot of alleys and down in a section of Southern California that are concrete. A lot of the alleys are concrete, and there's been a lot of surveyors go down there and you set a 1 foot offset to a PL, to a property corner on a prod. And so when you go around a block, you'll find quite a few lead tack and tags in the concrete, both front corners and rear corners. And what they've had happen is a contractor going in, tearing up a section of the alley, comes in, he finds, oh, hey, I got some PL offset lead tack and tags here. So he doesn't have a surveyor on staff. He somehow manually ties out these points, pours the concrete, comes back, resets this nailed lead tack and tag with the old surveyor. And we found guys that are dead, surveyors that are dead, and have had their lead tack and tag reset in brand new concrete. And according to the board, professional engineers, land surveyors here in California, that's illegal. You cannot reset another guy's tag like that. And we've seen a number of examples of this. We haven't been able to tie down who it is, but it is happening. They're smart enough to know that they got to do it. They're coming close. How close are they coming? A foot. It was brought to my attention by another surveyor, and he said the only way to get around it is that you got to find more. You got to find more property corners, more prods that are of record, and use those to see how good the ones are that are off. That's the only way to find out which ones are good and which ones are not good to use. But you're not alone. We see it down here in some very expensive housing areas too.
And I'm just going to reiterate to James that even in Minnesota, I mean, you get the best subdivision guys in the world. We go out and set our property corners, but we get those contractors that do exactly that. They will not notify the surveyor if things come out. So let's say I go back into that subdivision, it was just done within the last 10 years. I'm going to have a hard time finding some of those property corners in their front stakes, but not the back ones. Back ones seem they don't mess around with them, but those front ones where they put the utilities and everything else, they're all ripped up. So I have to do a little bit more land surveying in order, or go out further than my 4-corner lot that the guy said, oh, I just want to put in a new fence. Yeah, well, that ended up not being that. I had to do the whole block, survey the whole block and go around and find more evidence in order for it to do it. And they wonder, people wonder why, like even the state of California with corner record remonumentation with pre-con and post-con requirements, they wonder why we do that. Well, that's exactly why we do it. It's because it costs people money and it costs property owners money. And if you keep doing it, but is there a statute of limitations on construction? No, but I mean, there should be something about these contractors or these construction companies that do that. They should start finding them big time.
So there is one county up here that has started to do that. They pay to be on the, we call it blue stakes here in Utah, but one call utility locates. So anytime a contractor, because contractors are required to call that utility locates anytime they're doing anything, with digging. So the county surveyor actually gets notice anytime a one call utility locates request gets put in. So they can look at the construction area, and their response then to the contractor is, hey, there is a section corner within, I think their rule is 30 feet of the area you're working in, inside and outside of whatever rectangle or however it's requested. And they are required to put in a monument preservation record. And so they actually pay $1,000 fee, and there's an application to the county. If the monument is taken out, they lose their $1,000, and that money goes to then resetting a government monument. If the monument isn't disturbed, then they receive a portion of that money back at the end of construction. And that's that. I really like that. That's protected a lot of section corners in that county and some centerline monuments. That wouldn't, David, help you in that case because the county isn't keeping track of individual property corners or property pins like that, and that would be a whole other animal. But I really do like that effort by the county to preserve that, and it saves taxpayers money to reset these when they get done. It puts the contractors on notice of what their professional obligation is, and it actually puts some weight behind some of these monuments that have fines on them for being lost, and then you can't track anyone down. So that's one thing. I know there's a fee to be kind of connected to those systems, but for the government agencies, I think that is a very, very good idea.
So the county surveyor actually gets a
Yep.
notice that they're gonna dig. Wow.
Yeah, we were doing a new subdivision, and we had flagged up and protected the section corners. I didn't even know were doing this. It was when they first started. So we had put T-posts and flagging and lath around it, and we even had a conversation again. One of these contractors we trust, and be very careful around this area. You shouldn't be in here anyways, but here's a monument that needs to be protected. Well, they start construction and they put in their utility locates request across just the entire subdivision phase, and I get a call from the contractor saying, "Hey, I just got this I've got to fill out this application here for monument preservation. It's going to cost me $1,000. What's going on here?" And I called a county surveyor and had a chat with him, and that they had just kind of invested in this system, and the contractor made sure to stay away from that monument. It didn't get disturbed so they could get their money back, and it was a great idea. Well,
That's
we are
good.
past the half hour here, guys. I knew we'd kind of split this book into two, but I appreciate the discussion here, the ideas. So let's just do a little bit better here on our descriptions and add some qualifying calls to it there and be more descriptive in it. And we will meet on the 31st. So two weeks from now. Teresa, can you send me an email and I can respond with the information? I'll get some more information from them, but it's Weber County in northern Utah. But if you send me an email, I can get you more information on their application.
Excellent. That's one way to do that. Thank you.
Yeah. Jerry actually just sent an email out earlier today about putting a voluntary contact list together for Wisdom Wednesdays and Mentoring Mondays, because sometimes we want to kind of pass some information like that along. And so there's mine. Feel free to send me a note here, and Teresa, send me an email here, and I can get you that application, some of the other stuff, so you can take a look at it.
Coming up in the next section is going to be some information on bearings, and Wattles goes into a example of a case where the basis of bearings changes midstream. And I'd like to say that I'm going to disagree with that wholeheartedly. And I'm going to have a bunch of court cases that will be applicable to that. And rather than try to read each of those into this, if there's some way that I could communicate that ahead of time, or maybe have it in a position where you could put it up on the screen for those to read, it might be helpful.
Absolutely, James. If you want to send the court cases you're looking at, or if you have them downloaded, any of that information, if you can send that my way, I'd be happy to have them pulled up and ready to go when we hit those sections.
What is your email address?
Yeah, it's T Williams, TWILLIAMS at ensignutah.com. ENSIGNUTAH.com.
Okay,
And it's also in the chat, James.
Yeah, I threw it in
Okay.
the chat there. So
that's good. If anybody has questions about something I've said, and something I've referred to, you can reach me at, pls8xx@hotmail.com.
okay. Well, that works. Well, I appreciate it, everybody. Have a great couple weeks. If you're in the northern climes like Jerry, or in Utah like Jeremiah and I are, stay warm and stay out of the snow. And we'll see you in a couple weeks. And
Okay.
California guys, just
Okay.
enjoy yourselves. Just
We don't say anything. I'm just know when to be quiet.
yeah.
Don't look a gift horse in the mouth.
Amen.
I spent all last week in Florida, and it was pretty tough to come back. So.
Ooh, my.
Yeah, we did a week in Disney World with the kids. It's the first vacation in a couple of years.
Nice.
And we did it big, and it was a lot of fun. So
Hey, if we wanted to do a voluntary list, would it make sense to put together like a Google document or something, a spreadsheet? Then we could put it on and take it off as often as we wanted to, or change it or whatever. Just something we could
yeah,
share.
yeah, I'm going to get with Trent Keenan, Trent #1, and he can send that through his when he does his email blast, and just have him kind of take control of that. He already has some of this too when you guys register. Obviously, it would need to be voluntary and want to share that information, but the easiest way to get that disseminated among everybody, because there's a lot that listen to this that aren't here, is to get him to share it. And Kyle's secretly compiling all our emails too,
Openly.
openly.
And then I have a
we
quick question.
voluntarily give it to him. So
I have a quick question on your dates and times. Now my Teams is so messed up. So what is the next time we're meeting, and what is the accurate dates we're meeting? Because I had one that had an email from Trent that said the 10th, and now one that had the 17th. So what are the dates that we're meeting again? Are we doing every 2 weeks now?
yeah. So we still do we've always done every other week, but we hit the
Okay.
holiday, which threw a wrench in things, and then I was gone.
Oh, that's what it
We
was.
should
Okay.
have met, and so we've pushed it to the 17th and the 31st.
Okay, so
And-
then your website now is up to date, and the last email I have is up to date. Okay.
February is going to have to change because he's got the 7th and the 14th, but the 14th is going to be Valentine's Day, and if I hold class that day, my wife will murder me. So
Okay.
we'll make sure
With
just
love.
for sure the 31st, and then let's look into I'll get with Trent on February.
Okay.
All right.
Okay,
I'm
thanks
out. Thank
guys.
you, guys.
Appreciate you. Have a great night.
Thanks.